Yeah, they be like, who is this Mickey Truth girl? Who qualifies her to put a work on
What's up,
these
what's up,
people?
y'all? It's your girl, Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So let's get it. All right, y'all. So we haven't done a Boosie update in a minute in regards to his federal case. So I'm going to do a quick update. He did have court, I believe, last Friday. So let's take a look and see what went on. So as y'all can see here, this is in support of defendant's motion to compel discovery. As we go down, it says Mr. Hatch, of course, is coming requesting this court to compel the United States Attorney's Office to produce all recorded communications between the United States Attorney's Office and or its agents and the San Diego County District Attorney's Office and on its agents as it relates to the prosecution of Mr. Hatch. These recorded communications will serve two purposes for the defense of Mr. Hatch. One being that the investigation into Mr. Hatch was shoddy and unreliable, and the second being that the current prosecution of Mr. Hatch is the result of prosecutorial vindictiveness and as such a violation of Mr. Hatch's due process rights. Y'all, we've been hearing due process a lot the past couple of days, even in the YNW Melly case. Now, the request is not vague. The government has objected to Mr. Hatch's request for discovery as being immaterial, overbroad, and vague. The request is specific. Defendant is seeking all recorded communication between the U.S. Attorney's Office to include its agents and the San Diego County Attorney's Offices to include its agents regarding the prosecution of Mr. Hatch. As Mr. Hatch has only been charged in San Diego County the one time, this request should not be overbroad or vague. Further, the request is not immaterial, as will be discussed thoroughly. The discovery sought and discoverable under Rule 16. The request is discoverable under Rule 16A1E, which states upon the defendant's request, the government must permit the defendant to inspect and to copy or photograph books, paper, documents, data, photograph tangible objects, buildings, or places, or copies or portions of any of these items if the item is within the government's possession, custody, or control, and the item is material to preparing the defense. Okay, they still going to case law. We're gonna skip through all that because it's too early. I'm getting tired. Uh, duh, 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 duh. Man, they cited a lot. Facts which tend to show that the government is in possession of information helpful to the defense of prosecutorial vindictiveness are the following. The complete refusal by the San Diego County Attorney's Office to make Mr. Hatch an offer of a felon in possession charge in state court. The San Diego Deputy County Attorney's comments to Mr. Hatch's defense counsel that he had not made an offer to Mr. Hatch because he did not like Mr. Hatch for the reasons that he came into San Diego from another place, allegedly committed a crime, then led his fans in a fuck the San Diego police. Mr. Hatch, defense counsel witnessed the San Diego the San Diego Deputy County Attorney smugly grin and say to Mr. Hatch so long after Judge Morin offered Mr. Hatch a non-custodial deal. On the day Mr. Hatch was in state court filling out his change of plea forms, the San Diego County Attorney moved to dismiss the charges against Mr. Hatch. Moments before ATF agents arrested Mr. Hatch and charges stemming from the same alleged incident was filed in federal court. And then it goes on to say the court must compel the government to make such communication discoverable. It then goes in its opposition, the government contends that the defense is attempting to utilize Brady as a fishing expedition and a pretrial discovery tool. However, Mr. Hatch has a very narrow request of discovery, which he is claiming he is entitled to pursue to Brady. The request for all communications under the United States Attorney's Office and the San Diego County Attorney's offices relating to Mr. Hatch should not be extensive, as this present case is the first and only criminal case Mr. Hatch has had in San Diego County. The requirements of due process obligate a prosecutor to disclose material expiatorial evidence. Favorable evidence is material, and constitutional error results from its suppression by the government if there is reasonable probability that had the evidence been disclosed to the defense, the results of the proceeding would have been different. Here, the requested discovery material for two different avenues of relief for the defendant. If the requested discovery illuminates, the hasty course and low quality of this investigation into Mr. Hatch in the present case, then it is material. It says if the requested discovery reveals prosecutorial vindictiveness, then it is material. A claim of prosecutorial vindictiveness is a claim of due process violation, and there is a reasonable probability that if the evidence is disclosed to the defense, the charges will likely be dismissed. Ooh, for these reasons, they're like, hey, this is under Brady. Again, we just went over that with the YNW Melly case. So again, it says, for the foregoing reasons, Mr. Hatch respectfully requests that the court compel the government produce the requested discovery by Mr. Hatch pursuant to the federal rules of criminal procedure, due process, and Brady. Now let's go over here and take a look at something. So I was correct. It says right here, number 53, minute entry for proceedings held before Judge Kathy and whatever on October 13, 2023. It says the discovery is continued. Hold on. Motion to compel discovery is continued to allow the parties to address discovery and government to address in-camera requests from the court. The motion hearing / trial setting is continued to December 15, 2023, 11 a.m. In the courtroom. Then it says continuance granted. Failure to continue will stop further proceedings or result in a miscarriage of justice. October 13, 2023 to 12/15/2023. So what the world does that mean? It means they better get it together or this case is about to go bye-bye, okay? And I'll be honest, they've been making some good points for sure, okay? They've been trying, remember, they tried to get it out due to Second Amendment violations. That ain't fly. However, they've been coming hard. So we will see. Will Lil Boosie be his case? Due to, guess what? The prosecution fucking up. Doing backdoor deals. Sound familiar, right? We'll see. Well, with that being said, make sure you like, comment, share, subscribe, tell a friend to pull up on your girl, Mickey Truth. And as always, go over to MickeyTruth.com and get you that merch because you know your girl stay with that work. So until next time, holla! You rappers ain't safe. No matter what you go through, do what you got to do and conquer the world.